So we are delighted to have you all here this evening, and especially delighted to have our speaker, Dave McBride, as he focuses on the principle, the process, the reality, and the challenge of due process, a key part of the US Constitution. And I know it's specifically involved with two amendments, and that's about the extent of my knowledge, which is why we have Dave here to share his perspective on the history, some of the case law, and the current circumstances as due process has come to the forefront of much of our awareness about events occurring here in the United States. So let me highlight Dave.
Oh boy.
Turn it over to
I'd
him.
rather not see myself highlighted.
Well, don't look.
Okay. Well, let me start off with a disclaimer. Sue said all she knew about the due process clause with it was that it's in two amendments in the Constitution. And before I started to prepare for this class, that's about the extent of my knowledge as well. I'm not a constitutional law lawyer, and I've tried to educate myself for the purpose of this class. Um, and I hope that I get most of what I say right. But I invite anyone to correct me or question any point, and also to interrupt at any time with questions. I may not be able to see hands or either the digital hand or your actual hand, but so just unmute yourself and speak up at any point in time. I'm going to try to cover three things, but as is always the case, I'll never get through all three. The first is to give you some historical background to the Due Process Clause and its importance. The second is to try to do a very summary overview of the Due Process Clause or clauses. And then the third is to try to discuss some of the immigration cases that have been going on ever since the Trump administration began its effort to, I don't know how to describe what its efforts are, but its efforts to deport, uh, as I heard today by Stephen Miller, 3,000 people a day, um, which if they were to actually do that would mean there would be no due process. And I think that's one of the reasons they're fighting some of the issues in terms of the notice and hearings that are required. But let me start off with the general statement. The due process clauses are in two amendments. The Sixth Amendment to the United States Constitution says, and no person shall be deprived of life, liberty, or property without due process of law. That amendment only applies to the federal government directly. Um, and it wasn't until the 14th Amendment that there is a due process clause that directly applies to the states. And it provides that no state shall, uh, nor shall any state deprive any person of life, liberty, or property without due process of law. So the terms are the same. There are very generally two components to due process law. One is called procedural due process, and the other is called substantive due process. The procedural due process, as you might expect, deals with what procedures the government must follow before it deprives a person of life, liberty, or property. And that often involves issues concerning what type of notice is required and what type of hearing is required. The existence of the right to procedural due process is not a controversial constitutional principle. I mean, it's literally provided, and no one seriously disputes its existence or its wisdom. The arguments under the procedural due process doctrines turn on the question of whether there's been a deprivation and what constitutes life, liberty, or property that's protected from being deprived without due process, and then what process is required. Substantive due process is a different concept. Substantive due process requires that the government have, in general terms, an adequate reason for depriving someone of life, liberty, or property. Now, generally, that the test for whether the government has a legitimate interest in depriving someone of life, liberty, or property is a rational basis test. I don't think I don't know if there's ever been, but it's extraordinarily rare that a court has ever ruled that a government action was irrational or had no rational basis. However, there's a different standard that applies when a fundamental right or liberty is at stake. In that case, strict scrutiny applies. And strict scrutiny involves a much more difficult analysis for the government. Substantive due process has been a very controversial constitutional doctrine. It's been controversial. It's been criticized both by progressives and it's been criticized by conservatives. Before 1937, the Substantive Due Process Clause was used to protect economic liberty. So a lot of government regulations, particularly with respect to working conditions, a lot of the government laws that states pass to regulate working conditions, minimum wage hours, child labor, were declared unconstitutional because they presumably infringed the liberty interest of the worker to do as they wished in terms of contracting away their labor. Of course, the idea that there was a real equal bargaining between workers and employers in those circumstances was a fiction. But in any event, it was that substantive due process protection of economic liberty that hampered the New Deal up until 1937. And it was that doctrine that caused FDR to propose packing the court. And once he proposed packing the court, his court packing proposal got defeated and was quite controversial, and there was a great negative reaction generally to it. But it did have the effect, or at least some have argued it had the effect of causing the Supreme Court to retreat from the use of substantive due process to protect economic liberty. And after 1937, I don't think there has been a case that has applied substantive due process to economic regulation and declared it unconstitutional. But instead, what has happened is that the liberties protected by substantive due process have focused more on personal rights. And I'll get into that in a minute. But the reason that substantive due process in both areas, and for example, the right to an abortion was a substantive due process right. The reason substantive due process is controversial, and it was controversial with progressives when it was economic liberty that was being used to frustrate New Deal laws, and it's controversial with conservatives when it's substantive due process that's providing or prohibiting laws regulating a variety of what I'll call cultural issues. The reason it's controversial is that some people take the position that the due process clause deals only with procedure and that there's nothing in the language of the clause itself that would suggest that there's any substantive test to be applied particularly a substantive test that would protect certain liberties. The second reason it's controversial is that none of the liberties that are protected under substantive due process are actually enumerated in the Constitution in any way. So and I'll go through what some of them are, but as an example, the uh, right to abortion, as the court made clear in its Dobbs decision, is nowhere articulated literally in the Constitution. Not even the right to privacy or the right to personal autonomy, which is the liberty interest that underlies the right to abortion, even that liberty interest is not articulated specifically in the Constitution. So the substantive due process clause has been very controversial. Now, the history of procedural due process actually goes back to the Magna Carta, which was 1215. And the Magna Carta established the principle that prior to the Magna Carta, the king was above the law. Whatever the king decided to do was the law. The king was divinely empowered to do whatever the king wished and wasn't subject to any law. The Magna Carta was the first instance, at least in English law, at least as I understand it, where the king was subject to the law. And the way the king is subject to the law and the way the rule of law operates is that the government cannot deprive someone of life, liberty, or process without due process, which means without the law being applied to determine whether the person or the government has the right to do what they've done. And that is so fundamental to the rule of law. Without that due process protection, I think it's fair to say there would be no rule of law because there would be no procedure that would guarantee that the law is going to be applied in situations where people are deprived of life, liberty, or property. And I guess as a general matter, the rule of law is important for at least two very basic reasons. One is, of course, the protection of civil rights and civil liberties. But the other, less often cited, is that the rule of law is critical to the operation of the economy and financial markets. And if you want to see, and the reason the rule of law is so critical to the operation of the financial and economy is because it establishes a level of predictability. Because you can rely on people, except those who violate the law, uh, comporting with the rules that the law articulates. And so you can predict what should happen in the future. The current controversies over tariffs is a perfect example of what happens when no one knows what the rules are going to be in the future. And it becomes impossible to plan and it becomes impossible to invest when the rules are in a constant flux and are unknown. So the due process clause is essential to the rule of law, and the rule of law is essential to both our liberty interest and our economic interest. Now, let me go back to substantive due process. Substantive due process recognized, first of all, it was first articulated to recognize a right of privacy under the Constitution, that there were certain areas of private conduct that the government couldn't intrude upon. There's nowhere in the Constitution that says there's a right of privacy. There are some state constitutions that articulate a right of privacy, but not the federal. The right of privacy was found, at least initially, as part of a penumbra, what's called it was articulated that the Bill of Rights generally, all of the individual rights specified in the Bill of Rights, were based upon a presumption that people should have a certain right of privacy to be free of government interference. And the articulation is that the rights articulated in the Bill of Rights aren't exclusive, that there are other liberty interests that are protected under the right of privacy or the right of personal autonomy. And one of the first cases that actually concretely applied that was with respect to contraceptives. There was a law, Connecticut had a law that banned contraceptives, um, and that was ruled unconstitutional under the substantive due process grounds that it interfered with uh, people's right to decide for themselves whether or not they wanted to take a contraceptive or involved with all the sorts of issues in terms of medical and reproductive issues that were personal. Then there was a right of privacy to marry a person of a different race. The Loving decision was not just an equal protection decision, it was also a due process, substantive due process protection. The Roe versus Wade was a substantive due process conclusion that a woman has a right of personal autonomy or privacy to make decisions whether to carry a baby to term. That, of course, we all know that was overturned by Dobbs 3 years ago. And the and the implications of the Dobbs decision in Dobbs, the majority opinions stated that the conclusion in Dobbs would not have an effect on, for example, contraception or same-sex marriage, which is another substantive due process decision, because according to the majority, the right to abortion involved a factor that none of those others involved, and that was the potential or actuality of human life, depending on what your definition is of when life begins. Another area of substantive due process is the right to refuse medical treatment. And this could have implications with respect to efforts to legislate and preclude families from receiving gender transition care for transgender minors. The argument being that either the minor has a personal autonomy interest in making their own decision with respect to the care, or more probably on the grounds that parents have a privacy right to direct the raising of their own children. And that is a right that's been recognized by the Supreme Court in contexts other than medical decisions. And then, of course, the last substantive due process case was the Obergefell with the right to marry an individual of the same sex. All of those are substantive due process cases. Now, procedural due process, as I mentioned before, the biggest issues in procedural due process are, first of all, has there been a deprivation of a right? It's been held that negligent conduct by the government that results in a loss of property or even liberty or personal injury to an individual does not constitute a deprivation of property or liberty under the Due Process Clause. It's not clear whether grossly negligent conduct or reckless conduct or conduct that shocks the conscience, even though not intentional, would constitute a deprivation. So that's the first issue under procedural due process is there been a deprivation? The next issue is what is property? And that might seem easy and it's obvious in some circumstances, but when the issue was first addressed as to what is property, there was a distinction drawn between rights and privileges. So, for example, receipt of welfare payments were not deemed property protected under the Due Process Clause because the individual presumably didn't have a right to receive welfare. That changed in 1970 when the court first concluded that receipt of welfare benefits was a property interest that was protected by the Due Process Clause. But that has been the question of whether a government benefit or license is a property interest that requires due process is sort of bedeviled the courts. And sometimes it comes down to a question of how important is the benefit or the license. Other times it comes down to whether the government established terms for either the grant of the benefit or the revocation of the benefit. If it does establish those terms, then it's a property interest protected. So an area where is very difficult is what about government jobs? Can you be terminated from a government job without due process? Well, the court has ruled that if you're under a contract with the government, and the contract runs out and the government doesn't renew your contract, you have no property interest in the renewal of the contract. It doesn't matter that the government doesn't have to comport with any particular due process to do that. On the other hand, there is a due process right if the employment is one where it's expected to be permanent. In that case, if there's an expectation of permanent employment, it will be treated as a property interest. Other areas are a driver's license is a property interest. Public education is a property interest. So you can see that nothing's easy in the law. There's always hard cases. And the definition of property under the due process clause is a difficult one. Now, the next one is, what does liberty mean? And that's even more tortured. And we'll get to that with respect to the immigration cases. Freedom from physical restraint is the obvious liberty interest that's protected. So you can't be sent to prison. You can't be civilly committed without due process. Parental rights with respect to custody of children are a liberty interest. So parents cannot have their parental rights to a child terminated without due process. Foster families, on the other hand, have no liberty interest. So foster families' custody of a child can be terminated without due process. Now, typically there is process that's involved, but it's not constitutionally mandated. Deportation and exclusion from the country. As a general matter, someone coming to the United States who seeks entry has no due process rights with respect to how the government determines whether or not to admit that person into the country. So there's no liberty interest if you are outside the country and you're coming to the United States and you're seeking entry and you haven't been admitted and the government doesn't grant you admission. You have no claim under the due process clause that you've been deprived of liberty. We'll come back to that in a minute. Another area of difficult definitions on whether it's a liberty interest is with respect to prisoners. What things can the prison do to a prisoner that require due process and what don't require due process? So revocation of parole or probation is a liberty interest. It requires due process. But the opportunity to obtain parole is not a liberty interest unless the state has granted a statutory right to obtain parole, in which case that right becomes a liberty interest. There's no liberty interest in minimum versus maximum security. So you can be moved from minimum to maximum security without due process. But there is a liberty interest in being segregated. So you can't be put into solitary without due process. Transferring from prison to a mental hospital, that's a liberty interest. So you can see that the operation of the due process clause is hardly self-executing, and it inevitably gives rise to a number of difficult issues. So that, in the context of substantive due process, those fundamental rights, the questions that are involved are these, and these come up in every case. Is it a fundamental right? That was the issue in Roe versus in Dobbs overturning Roe versus Wade. The Roe court concluded that a woman's right to make a determination about whether to carry a fetus to term was and is a fundamental right, and the government could only deprive that person of that fundamental right if it had a compelling interest in doing so. And the compelling interest that the court in Roe found was the potentiality of life, which the Roe court said doesn't become compelling enough to override the woman's right to make the decision herself until the third trimester or the end of the second trimester. The Dobbs court said there's nothing in the history. The Dobbs court said in determining whether there's a fundamental right, you first look to the terms of the Constitution itself, then you look at the history of how that conduct has been treated historically. And so Dobbs said there's nothing in the Constitution that addresses a woman's right to have an abortion. And in our history, up until Roe, the typical rule was that abortion was illegal. And so the Dobbs court said that there is no fundamental right to have an abortion. Roe said there was a fundamental right, and it subjected that right to strict scrutiny and said under strict scrutiny, the government can only interfere with it at the third trimester. Now, actually, in Casey, they backed it up and they changed the third trimester to viability, which was the underlying rationale for the third trimester in Roe. The Roe court picked the third trimester as the demarcation line on the theory that that's when the fetus became viable outside the womb. In Casey, the court said, oh, we're going to just say it's viability because the medical science had moved to the point where viability might occur earlier. In addition, the Casey court said that the government has other interests in regulating abortion earlier than viability to protect the child and the mother in terms of medical procedures and such. So that's the first question. Is it a fundamental right? And then the second question is, has the right been infringed or deprived? Third is there a sufficient justification for the government's infringement of the right? And then fourth, is the means that the government uses to accomplish its compelling justification for infringing the right, is that means sufficiently related to the purpose? In other words, is it overbroad or is it narrowly targeted? And those are the issues that come up in literally every substantive due process case that involves liberty interests. Now, recent immigration cases. I'm going to divide this into two areas. And let me tell you, I've spent days reading decisions in this area, and there was one that just came down today that I haven't read yet. So, and I haven't mastered these decisions, so I'm going to give you a very general overview, but dividing it into two questions. When does due process apply, and what process is required? Now, with respect to the question of when does due process apply, the United States Supreme Court, in its emergency decree in the alien in Trump versus JGG case, that was the alien enemies case that went to before the United States Supreme Court, was decided April 7th. In that case, the United States Supreme Court said it's well established that the Fifth Amendment entitles aliens to due process of law in the context of removal proceedings. So the detainees, the people that were captured by the government to be sent to El Salvador or wherever else, are entitled to notice and the opportunity to be heard, quote, appropriate to the nature of the case. More specifically, in this context, AEA detainees, that's Alien Enemies Act detainees, must receive notice after the date of this order that they are subject to removal under the Act. The notice must be afforded within a reasonable time and in such a manner as will allow them to actually seek habeas corpus relief, which the court in that case concluded was the only mechanism by which the court would have jurisdiction over an action challenging an immigration decision. That's significant because under some of these immigration statutes, including the Alien Enemy Act, there are provisions that seem to preclude judicial review of the decisions made by the government. And that it gets very complicated, and I haven't mastered that, and so I can't even explain generally how that operates. But in most of these immigration cases, one of the arguments that will be made by the government is you, the court, don't have the power to review the conduct that this plaintiff is seeking for you to review. So you don't have any power to review whether or not we're properly applying the Alien Enemy Act. Now, there was an old Supreme Court decision from years ago, decades ago, that stated, and the Alien Enemies Act has only been utilized, I think, 3 times before, so there's not a lot of case law for obvious reasons. But there is an old Supreme Court decision that did grant that the court could review actions challenging the Alien Enemies Act under a habeas corpus procedure, but the issues that could be raised were somewhat limited, and I'll come back to that in a little bit. Here's the other issue that came up, and at least before that Supreme Court decision, and I must confess, when I first read the Supreme Court decision, I thought, well, boy, it must be pretty clear. And then I went back and started reading law review articles from 3 or 4 years ago as to what the due process rights were in the context of immigration, and it became anything less than perfectly clear. So let me just walk through. Non-citizens do not have due process rights in connection with their attempts to enter the country before they enter the country. So someone that's sitting in a boat in New York Harbor who's applied for admission to the United States and is denied the admission does not have any claim under the due process clause that their rights have been violated. But what happens if you get off the boat and you come on to Ellis Island? You haven't been admitted yet, but you're on the territory of the United States. Do you get due process rights at that point with respect to the decision the government makes whether to admit you or not? Well, the courts have entertained on that question different approaches. One approach, evidenced by some decisions, is that if you are physically in the territory of the United States, legally or illegally, however you got there, you have a due process right. And there are decisions that arguably support that proposition. But there are other decisions that have what this law review article I read said are two fictions. The one fiction is what's called the entry fiction, which is that persons who have not been admitted to the United States, even though they are physically on the ground, don't have due process rights because they haven't, quote, entered the United States. It's as if they were still on the boat in the harbor. Another is what's called the parole fiction, which is you're on the boat in the harbor. The government says, we don't want to leave you on that boat while we try to figure out whether to admit you or not. That creates problems for you. It creates problems for the harbor. It creates problems for the carrier. All right, you can come on to Ellis Island, and we're going to put you in a room here, and we're going to detain you here until we can figure out whether to admit you or not. that um, that doctrine, some court decisions had suggested, at least before this most recent Supreme Court decision, that if the government allows you to come in, but subject to certain restrictions and limited rights, all that you're entitled to are whatever process rights the government has given you when they admitted you. And you can't bring a due process claim and ask for more. Then there's a third style where the Supreme Court said you don't have due process rights unless you are um, you've become part of the population and have developed ties over time with the country. And that is another where your right to due process doesn't accrue until you've sort of been around a while and gotten involved. Now, there is a statute that creates something called expedited removal, and it provides that if you are apprehended, it says any non-citizen who enters the United States without inspection, in other words, you come across the border and nobody let you in, you just snuck in, who was never admitted or paroled, meaning taken into custody and then set free to await a subsequent determination as to whether you're entitled to stay or not. So you weren't inspected, you were never admitted, you were never paroled. If you're encountered anywhere in the United States and you cannot prove that you have been present in the United States for 2 years preceding the immigration officer's determination that you are inadmissible, you can't come in, then you're only entitled to the procedure, or this is the argument. What the statute would say is you're entitled to a hearing before the ICE agent. He'll interview you, or she'll interview you. The agent will interview you and will decide whether you're admissible or not. And if the agent decides you're not admissible, that's it. You're out. That's your process. That's all you're entitled to. But the law also says, but you are entitled to one other thing. If you claim that you want to be admitted because you're being persecuted in the country to which you would be sent back, or you're seeking asylum, then in that case, you get an interview before an asylum officer, and the asylum officer can determine whether you have a legitimate fear of persecution or need for asylum. And if the asylum officer says you don't, then you have a right to go before an immigration judge. But the immigration judge is supposed to resolve the matter within 24 hours, if possible, but no more than 7 days. Now, the reason I went into all of that is because that act is being used by the government now to argue that it's giving adequate notice to detainees when they are told 24 hours before they're sent to El Salvador, we're going to send you to El Salvador. And then they have another 24 hours and in the subsequent 24 hours, they do not file a habeas petition in a court. And the government's been arguing that is sufficient due process. And every court that's addressed the issue so far, at least that I've found, said that's not sufficient due process, including the United States Supreme Court. So who does get due process in the immigration arena? Well, we know the people that are charged with being alien enemies, they get due process. The Supreme Court's just ruled on that in that case. And in that context, there's a debate as to due process with respect to what issue. They clearly get due process with respect to the question of whether they are or come within the definition of an alien enemy as defined by the proclamation that the president issued. So, for example, the president issued a proclamation concluding that a particular gang from Venezuela, I guess, is an alien enemy. And if you're a member of that gang, you're an alien enemy, and they can just summarily throw you out. Um, that issue you can challenge. So you can say, I'm not a member of that gang. But what about the issue of whether the existence of that gang in the United States constitutes an alien enemy within the meaning of the Alien Enemy Act so that the president could even issue the proclamation? The government has argued that that issue is not available for judicial review. However, there's two district courts, or no, three, I think, that have now concluded that the President Trump's proclamation purporting to expel people under the Alien Enemies Act isn't authorized by that act. Um, so that's one area in which due process clearly operates, but it's still debatable what process is required. And in fact, the Supreme Court, the last time it addressed this issue a couple weeks ago, said, well, we can tell you 24 hours isn't sufficient notice, but we're going to remand the case back to the Fifth Circuit, which is the most arch conservative circuit in the country, for them to decide what process is reasonable under these circumstances. The other courts outside of the Fifth Circuit that have addressed that issue have generally been talking about several weeks of notice. Another area where the due process clause has operated is with respect to some people come to the country. In fact, this is the Garcia case, the fellow that was erroneously sent by the government to El Salvador to the prison. Under the Alien Enemies Act, they grabbed this guy, but he had previously applied for asylum in the United States and had a court hearing. And in the court hearing, the court ordered that he not be removed. It's called withhold removal, because the court concluded that there was a legitimate issue as to whether he would be safe being sent back to wherever he was going to be sent. 5 days later, I think it was, he's grabbed by ICE agents under the Alien Enemy Act proclamation and sent off to El Salvador. Except the government says, oh, you know what? We did that by mistake. We didn't realize he was under this withhold removal order saying that we couldn't send him to El Salvador or anywhere else for that matter. And so we mistakenly sent him there. And so you would think that the natural reaction would be, okay, so we mistakenly sent him there, we'll bring him back. Except the Trump administration is claiming, well, he's not a member of the gang that we said he was a member of. He's a member of a different gang, and we don't want him in this country, and we shouldn't have to bring him back. So the case went up to the U.S. Supreme Court on an emergency basis. The district court had ordered the government to, I forget what the exact words were.
Facilitate.
Yes. No, well, facilitate, but there was another word that the Supreme Court said, well, that may not be right. I got to find it here. Effectuate. The district court and the circuit court said, you sent this guy away by mistake. You're hereby ordered to effectuate and facilitate the return of this man that you sent away mistakenly. Went up to the Supreme Court. Supreme Court the government actually won on the issue. It was the government that appealed up to the Supreme Court. On an emergency basis, because they said that the case that had been brought on behalf of this individual was not brought by the proper procedure. It should have been a habeas proceeding as opposed to an Administrative Procedures Act proceeding.
So
And
David,
yeah,
would effectuate mean make it happen, bring him back?
yeah, and that's what the Supreme Court said. Maybe that's beyond your power to do. So the
Why
Supreme
did
Court,
they say that?
well, because he was outside the country. And so the United States government, theoretically, at least, theoretically, I say, theoretically did not have the power to send in the police or the troops or whatever and take him in custody if the country in which he was located wouldn't allow it. Now, as a point of historical fact, whenever this happened in the past, the United States always did ask for him back and they were always sent back. This wasn't the first time the government mistakenly deported somebody. But the Supreme Court said, well, we don't know that you can order the we don't know that you can order the government to effectuate the removal, but we do agree that you can order the government to facilitate the removal. So it goes back to the lower courts, and now there's a big argument over what does facilitate mean? The government says facilitate means we need to remove any obstacles that we have put in the way of his being returned by El Salvador. But it doesn't mean we have to do anything affirmatively to try to bring him back. And the two courts that have addressed that argument in that case, both the District Court and the Fourth Circuit Court of Appeals said, no, facilitate doesn't mean you only have to remove obstacles. You've got to do more. So now the district court is now is undertaking discovery to try to find out, well, what did the government do? Except in that regard, it gets complicated because the Supreme Court said that when the when the when the court below starts to investigate whether facilitation has occurred, the government may have a right to secrecy with respect to the conduct of foreign relations that would be protected from discovery or from the court finding out what the government did. So now the government is claiming all sorts of privileges with respect to not producing evidence of what actually happened in terms of the efforts to, well, in terms of whether Garcia is being brought back or not. Now, interestingly, there is another case that was just decided, someone who was someone that, this is another area that's of protection. There are, you cannot just remove someone to any place. Let's assume that an immigrant's come into the country and they're not allowed to stay here. Where are you going to send them? Well, you can send them anywhere to where they consent to being sent, but that would require also some other country agreeing to accept them. And many countries won't accept them. Or you can send them back to the country they came from, unless there's a persecution or asylum problem. Or you can
What?
send them to a third country, unless there's a persecution or asylum problem. And in this case, DVD versus Homeland Security, the decision was made to send people to Sudan, which is undergoing a horrendous civil war. And they actually, with almost no notice, maybe no notice, but almost no notice. I think they were given 16 hours notice, the court said, and it was overnight. You're going to Sudan. The court said, wait a minute, wait a minute. These people had a due process right to be told you want to send them to Sudan, and they had a due process right to a hearing as to whether or not they would be subject to persecution or need asylum in Sudan. So and there was someone that was sent despite the order being entered, I believe. So the government now has, with respect to this person, who apparently was also mistakenly sent to Sudan, is bringing him back. And I just heard an interview with a law professor from Emory on NPR tonight, on PBS NewsHour tonight, asking what's the difference between this case where the government is agreeing to bring the guy back from Mexico and the El Salvador case where they're not doing anything to bring Garcia back. And the law professor said there is no difference. There's no way to explain why they're doing one and not the other.
So, David, I have a question on you on just that fact.
Mm-hmm.
Because the government is acting very arbitrarily. It says this due process isn't defined. We don't have this due process down. But if you act one way in one case and then decide to act in another way in another case, aren't you in fact acting arbitrarily? And then how do we as citizens, because any of us can get apparently picked up and deported without any due process,
Mm-hmm.
how
Well,
are our rights protected?
Well, let's go back. First of all, the whole point of the Garcia decision, in fact, I'll read something to you that the Fourth Circuit Court of Appeals wrote in the Garcia case. Said the Supreme Court's decision does not, however, allow the government to essentially do nothing to bring Garcia back. It requires the government to facilitate his release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Thus, the government's argument that all it must do is remove any domestic barriers to his return is not well taken in light of the Supreme Court's command that the government facilitate his return. And here's the paragraph that addresses the issue that you're raising. The executive possesses enormous powers to prosecute and to deport, but with powers come restraints. If today the executive claims the right to deport without due process and in disregard of court orders, what assurance will there be tomorrow that it will not deport American citizens and then disclaim responsibility to bring them home? And what assurance shall there be that the executive will not train its broad discretionary powers upon its political enemies? The threat, even if not the actuality, would always be present, and the executive's obligation to take care that the laws be faithfully executed would lose its meaning. And this is a passage written by one of the leading conservative judges in the United States. And some people have, this was Judge Wilkinson. It was after Judge Wilkinson issued this somewhat impassioned plea that the Supreme Court then entered an injunction restraining any further removals under the Alien Enemy Act until it further decides matters. And subsequent to that, there have been two cases that have three or four cases that have decided that what the Trump's proclamation and his efforts to remove people as alien enemies isn't authorized by the Alien Enemy Act because it doesn't come within the meaning of that act. It's interesting because in one decision that did that, the court said in deciding whether or not the president has the power under the Alien Enemy Act to remove people, we have to accept as true any declaration the president makes with respect to what the facts are. So we have to accept as true everything that the president says in the proclamation about this gang, their relations with the Venezuelan government, their activities within the United States. We have to accept all that as being true, even though I will say parenthetically that there have been news reports that the State Department initially, or the CIA, I think was one of the intelligence agencies initially had issued a report saying that none of it is true. And then the person who issued that report was then withdrawn by the government or ordered withdrawn. And I'm not sure what happened to the people who issued the report. But in any event, the court says we've got to accept all that as true. But in that case, the court said, even accepting all of that as true, what is described in the proclamation doesn't fit the Alien Enemy Act. And so that'll be that'll be obviously a major issue that will get to the Supreme Court. But the Supreme Court has entered its own order, ordering the government not to deport anyone under the Alien Enemy Act until further order of the Supreme Court. And presumably what the Supreme Court's waiting for is the case that will come up that will put before the Supreme Court the issue of whether the proclamation that Trump issued to deport people under the Alien Enemy Act is in fact authorized by that act. So
It's 8 o'clock.
I guess that's as far as I've got time to go. It is, I'll just close with this. And I've been practicing law now for, God, 50 some years. And the one thing I've learned is that notwithstanding all the laws you make, notwithstanding all the court cases, notwithstanding all the contracts you write or rules that you articulate, if you don't have people that operate in good faith and are actually attempting in good faith to comply with those rules, but you're dealing with people who just are out to evade the rules by any means possible, the rules are going to break down. The system is not going to work. The system really requires a certain amount of good faith on the part of people who are trying to comply with or apply the law. And I think I have read that when the Supreme Court issued the order enjoining the government from any further deportations under the Alien Enemy Act, it did that in extraordinary circumstances. It issued that order at midnight. It's something it never does. It issued the order when there wasn't even really perhaps an appeal before it. And a lot of people have speculated that it issued the order with such speed because it no longer trusts that the Trump administration is acting in good faith, at least with respect to immigration issues. And so a lot depends on, you can argue the law, and lawyers can be very creative when it comes to making arguments, including arguments that are ultimately determined to be wrong, but there is at least a good faith basis in believing that the argument is right. I'm not sure that this administration is operating in good faith. Now, having said that, I say I'm not sure because I have been trying to read whatever arguments the administration has made in its support of what it's done. And I haven't been able to get a hold of much of that. So I'm not sure I understand what their arguments are. So I probably don't have a good basis for making a judgment as about whether they're operating in good faith or not. But I will say this, there have now been 2 courts that have concluded that the government, the Trump administration, has violated court orders in those cases. The one dealing with, I think with Garcia, and the other dealing with the change in the case involving where they changed people's removal destination to Sudan. So there's at least two cases where the court has concluded that the administration was intentionally or consciously not complying with the court orders. But those are, I hope that stopped. Those decisions were with respect to conduct that occurred sort of early in this process. And my hope is that with the rulings by the U.S. Supreme Court, that's going to end, because certainly lawyers now are personally at risk if they were to engage in conduct that the court concludes is in contempt of court or violation of court orders. The lawyers that are practicing in that case or involved in that case could be disciplined themselves or lose their license to practice. So there are some practical constraints on what the government will do, or at least what the lawyers will do. And some of these arguments seem pretty far-fetched. I mean, the government's taking positions in the cases now that differ from positions the government took in earlier cases on the same issue. Now, with a change of administration, that sometimes happens. I mean, in fact, sometimes it often happens. The administration that the Biden administration was on one side of an issue, Trump comes in, one side of an issue that's in court, and the United States government is taking position X. Trump administration comes in and they say, that's not our position, and they switch. So it's not unusual, I guess I should say, and it's not impermissible. But when it's an issue about like when notice is required, and the government has previously conceded in oral argument that notice in a hearing is required, for the government to come in now and say no notice or hearing is required is need to pay attention to the basis for that contention. I have a new principle for myself that I'm trying not to form moral judgments with respect to the conduct of others or the government until I can confidently say, I know the best argument that can be made for the position that I disagree with. And
Can't hear you, David.
yeah, I'm sorry.
Can't hear you.
Oh, I was just saying that I have a new principle for myself, that I'm not going to form moral judgments about what others do or argue until I can confidently say I understand the best argument that can be made on the other side of this issue, and even understanding that best argument, I still think the argument is immoral or the conduct is immoral. And I'm not in a position where I have enough mastery of the positions that the Trump administration is arguing to be able to say, I think they're not acting in good faith in how they're applying the law, but there are certainly red flags flying, and I wish, frankly, I wish I knew more.
Dave, can I raise one thing? I hope I'm wrong about this, but I understand or heard that there's a provision in the big, beautiful bill that no federal court could enforce a contempt citation. Going to your point about attorneys being constrained by the fear of discipline.
That's correct.
Yeah, I wasn't aware of that. I
Yeah.
wasn't aware of that. I thought there was a nation. I thought that's the other big issue that's currently before the Supreme Court. In the birthright citizenship case, the Supreme Court took an appeal, but not on the question of whether birthright citizenship is constitutional right or whether Trump's declaration that certain people born in this country aren't entitled or aren't citizens, but took it on the issue of whether you could issue a nationwide injunction. A nationwide injunction is when litigants come before the court, plaintiff A makes argument and says the government can't do X. The court says, yes, you're right. The government can't do X. Now, what kind of order does what does the court enter? There's the most conservative is the plaintiff who brought the case, the government can't do X to that plaintiff, but it's not restrained from doing X with respect to anybody else. Another step is, well, the government can't do X within the district in which the court sits. Another is it can't do X if it's a circuit court of appeals that it's ruled in the circuit in which the court of appeals sits. Another rule is the judge has the discretion to order the government not to do X throughout the entire country. And that power by judges has been controversial from both the left and the right. The Biden administration was upset with nationwide injunctions that were threatened by a district court judge in Texas who was trying to restrain the distribution of certain drugs, abortion drugs.
Yeah.
By a similar, on the flip side, the Trump administration and other Republican administrations have been concerned by nationwide injunctions by individual judges that have precluded the government from doing X throughout the entire country when it's something that the judge determines is illegal. And the Supreme Court has been very critical over the last number of years, or very concerned about the use of nationwide injunctions. And so the birthright citizenship case was that it raises that issue. The court in the birthright citizenship case determines that Trump's declaration that certain people born in the United States are not citizens for various reasons is unconstitutional, contrary to the Constitution, contrary to the 14th Amendment. And so what kind of injunction should that judge enter? Should the Trump administration be precluded from effectuating the terms of that executive order throughout the country, or only with respect to the plaintiffs in that case, or only with respect to a certain circuit or district? And the need.
Question: who makes the laws? I mean, I thought that the laws were the purview of the House and the Senate.
There's no law that, not yet. There is one that's pending. I think the Republicans, and it may be in the big beautiful bill. I'm not sure. I think there is a bill pending that would either restrict or outlaw nationwide injunctions. The problem with that is this happened in the immigration cases. In the immigration cases, the Supreme Court said in that same decision where it said you're entitled to notice in a hearing, Supreme Court said the way that you challenge this immigration decision is a habeas proceeding. And a habeas proceeding must be brought, not may be brought, must be brought in the district in which the plaintiff is located at the time he's being deprived of his liberty.
You mean not in Louisiana?
Well, it may be in Louisiana if that's where he is. Now, what's happened here was that people brought...
He wasn't even charged, so it should be in the area where you committed the crime or where you were charged, right? I thought.
Well, not necessarily, because under the Administrative Procedures Act, it depends on your basis for challenging. It depends on the grounds in which you challenge. For example, in that case, the plaintiffs brought the claim under the Administrative Procedures Act, which allowed it to be brought in the district DC circuit. And the plaintiffs wanted to be in the DC circuit. And the Supreme Court said, oh, no, this is not an Administrative Procedures Act claim. This is a habeas claim, and a habeas claim must be brought in the district in which the plaintiff is located at the time he's deprived of his or her liberty. The problem is that a case would be brought in the Southern District in New York, and the court would declare that there's a due process right to hearings before you can be deported. And the Trump administration was moving people around districts, trying to get somebody who's in the Southern District of New York, taking them into custody and moving them to some other place where the ruling of the Southern District of New York judge wouldn't apply. And the Supreme Court was aware of that at the time it was discussed, at the time the nationwide injunction issue came before them. And
So
so
the federal government has a right to take you across various state lines
well,
legally.
they do have a right to take you into custody. They do have a right to take
But
you in.
you don't even know what you've done. You haven't been indicted. You haven't had a day in court.
Well, you don't have to be indicted under the immigration laws before they can take you into custody. I don't think even under the Supreme Court's ruling. Under the Supreme Court's ruling, you'll have to be given notice. Well, I shouldn't say that. I'm not. This is the area where I'm not
It's cloudy.
the master of the law in this regard. But I'm not
They're
sure that
picking up people with legal green cards who are here according to our immigration process.
Yeah, and they're entitled to
And you go to report when you're supposed to report, and they pick you up there and haul you somewhere else. So
All
I
right,
don't think we have any process.
Maria and Dave, I need to
Yeah.
call a point of order. I think we
Okay.
could go on for a very long time here. Um, I'm reminded of the wisdom of my decision not to go to law school at an earlier point in my life. But I want to thank you, Dave. You have done just an amazing amount of research and presented this in a way that keeps us focused. But you highlight the issues, the conflicts, the challenges. I think your conclusion is dire. And I think there is no question, my personal opinion, that this issue of the administration ignoring judicial decisions is going to trigger a circumstance that it's difficult to envision that it would actually occur, and to envision how and whether and why, in what way it will be resolved.
Yeah,
These are challenging times. There's no clear view, in my opinion, of where this is headed. I think that we are all rightfully beyond concerned about what is happening and what is on the horizon. And to your point, laws in and of themselves do not solve anything. And the system only works if the players in the system play according to the system. And we are going to see, I believe, what happens when the rubber meets the road with this. And I can't begin to imagine how it's going to be resolved. But we are so grateful to you for bringing all of this to us this evening. And
yeah, I appreciate the opportunity. I mean, it's been a lot of work, but I appreciate the opportunity to force myself to do it. Let me just say one last thing. You probably know of the decision yesterday, and then another today, declaring that Trump's tariffs are unconstitutional and illegal.
right.
And I actually think that those tariffs are so unpopular with the business community that otherwise is or was supporting him, that I think it's an Achilles heel that he's going to have to comply with those decisions And I think it's going to spill over into forcing him to comply in other areas as well. I'm becoming a little bit more positive about the prospects of the judicial system eventually working. But it's close. It's very close. And again, it's if the administration operates in bad faith, then all the rulings in the world won't fix that.
All right. Well, thank you all for being here. Thank you once again, Dave. And we will look forward to seeing you on future Thursday nights. And I expect we'll have Dave back giving us some more legal perspective and wisdom on our circumstances as time proceeds. So thank you all.
Thank
Thanks,
you.
everybody.
Thank you, Dave.
Awesome.